Yeah, thank you, Tom. So we're going to look at airport liability insurance now, and we've picked the AVN 104 form. Tony, if we can go to the next slide. Before we get into AVN 104, I really just wanted to touch on the aerial wordings. The aerial wordings have been around for many years, I think from the 70s, and 48 fly and the major airport wording to an extent we still see in common use in the market. And I really wanted to just discuss a few of the reasons why we really shouldn't be using aerial wordings and the improvements that have been made with the AVN versions of those aerial wordings. So as we discussed, 48 fly has been superseded by AVN 126 and the major airport wording by AVN 104, which we'll talk about in a moment. But if you look at some of the features of the aerial wordings, you know, they're on an accident basis rather than an occurrence, which we've talked about in previous sessions. There's no aggregate stop clause within those aerial wordings. So to say that if the aggregate limit of the policy is exhausted, it doesn't necessarily mean that defense costs are no longer payable by insurers. There's no provision for deductibles. You have to state what the business and operation of the insured is within the policy. You have to state the exact premises that are being used by the insured rather than at any location, as we just looked at. The bodily injury definition doesn't include sickness or disease. The property damage definition doesn't include resultant loss of use of lost or damaged property. In the airport wording, there isn't an air traffic control exclusion. You've got various conditions precedent included within the wordings, which may conflict with the Insurance Act. There's no cover for baggage or cargo whilst in the insured's care, custody and control, which may be an issue for an airport operator. And there's a no fraud clause within the airport wording, and the fraud clause within 48 fly would not be compliant with the Insurance Act. So there are a myriad of reasons why the aerial wording has been superseded, and those improvements have been made in the AVN versions, which it is preferable for practitioners to use. So let's move on and have a look at AVN 104 in some more detail. Now, in contrast to AVN 98A, AVN 104 is a single insuring agreement policy. We don't have these sections like you had in the AVN 98A. So here we just have a single common theme of bodily injury or property damage caused by an occurrence and arising out of their business as owner or operator of the airports specified in the schedule of the policy. So it's a very broad coverage for any liability that results in BI or PD arising out of the ownership or operation of the airports. And that's quite a distinction to where we have the different sections for products liability, premises liability, hangar keepers, and the different coverages that we saw under 98A. Tony, let's look at the next slide. So then, because we've got that quite broad insuring agreement, we want to look closely at the exclusions as to what's not covered, therefore, by the policy. So the first one then, we're not covering property owned, rented, leased, occupied by, or in the care, custody and control of the insured. So we're not covering first party property. In other words, this is a third party liability policy. However, we have this other than PD2 right back. So whilst we're not covering first party property, we are going to provide cover for A, aircraft that are not owned on the ground in the care, custody and control of the insured for the purposes of storage, servicing, handling or maintenance. So you might notice something similar there to something we just looked at. This is talking about ground hangar keepers cover. So aircraft not owned on the ground in the care, custody and control, storage, servicing, handling or maintenance, this is ground hangar keepers cover. The next one, B, vehicles not owned by the insured, but whilst they're at the airport specified in the schedule. So vehicles not owned by our airport operator, whilst they're on the airport premises, they are covered by the policy if they're damaged. And then the third one, an important one normally for an airport operator, baggage and cargo. It's not owned by the insured, but if it's in their care, custody and control, that's treated as a third party property. We're not going to exclude that property just because it's in the insured's care, custody and control. So, if they damage cargo whilst it's being loaded, or they damage passenger baggage whilst they're handling it at the airport, that's covered by the policy as a result of that 3C right back. Let's move on, look at another exclusion. So the next one, there's a bit more to it, but really we're talking about an aircraft liability exclusion here. So we're not covering BI or PD caused by aircraft. However, there is a right back. So the exclusion doesn't apply to BI or PD that's caused by aircraft not owned, rented, leased by the insured, whilst they're on the ground and in the care, custody and control of the insured for purposes of storage, servicing, handling or maintenance. Again, so this is liability, and it's important to note that this is liability caused by aircraft. So this dovetails with the property damage to non-owned aircraft that we looked at in exclusion 3. This is now liability caused by an aircraft that's in your care, custody and control. Now, note that an airport may need a degree of aircraft liability cover, so non-owned aircraft liability, in-flight non-owned aircraft liability. For example, airports quite often will hire in an aircraft to do calibration of their runway systems, so they pick up a non-owned aircraft liability exposure. They also might have, we've seen quite a few instances where airports are using drones, UASs, to do maintenance work, surveys of the buildings, runway surveys. So there's an airport liability exposure. So you need to think if you need to incorporate liability arising out of aircraft to a greater degree than is provided by the standard AVN104 form. Let's look at another exclusion, exclusion number 5. So it's a product liability exclusion. If you remember that it's a very broad insuring agreement that we looked at, any liability arising out of the ownership or operation of the airport. So that would include products liability. So what we have to do is make sure that we have an exclusion for products liability other than, and it's important the part in green, the exclusion doesn't apply to goods or products used in conjunction with aircraft. So this is your aviation product liability really that's written back, or the supply by the insured of food and drink at the airport. So we're giving the product liability cover they need, but excluding product liability that may arise in a non-aviation context as by virtue of the wide insuring agreement. And then I've just highlighted there, exclusion number 9 within AVN 104 is that vehicle exclusion and right back that we looked at a moment ago under AVN 98A. It's exactly the same one. So again, we're excluding vehicle liability, but giving the right back for vehicles being used within the confines of the airport premises.
Gareth, just before I assume you move on to the next slide, we've had a question just on the previous slide. So if Tony can go back for one moment to the last slide in exclusion 4 with the right back for bodily injury or property damage to aircraft not owned, rented or leased by the insured. The question is, does that right back apply to the insured staff, i.e. airport staff?
As in, are we excluding bodily injury to the airport staff? I mean, the answer to that question would be yes, by virtue of it's another exclusion in the policy, in fact, where we're excluding liability for bodily injury to employees of the insured and or liability under EL or workers' comp insurance.
Okay, yeah, and Naomi, who asked the question, please do just advise maybe with a follow-up question if that wasn't what you were covering. But yeah, I think we were looking, Gareth, specifically at those right back words and whether they, and in particular the exclusion not applying to BI, I assume could apply to the insured staff. But it does seem to be quite specific to aircraft owned, rented or leased by the insured. But I assume we mean staff where there may be some kind of interaction with those aircraft.
Yeah, can I add something to that? I think on its own, it looks a little bit odd. And you think, well, how can an aircraft cause bodily injury and property damage? But of course, the aircraft can cause bodily injury and property damage if, for example, it jumps its chocks or something like that, or you know, just moves whilst it's being managed by the insured staff, it damages somebody else, some other property, or it's not the person who's managing the aircraft, but it's the aircraft itself. It clips somebody else's wing or something like that, and maybe causes injury to another person, a third party. And these incidents do happen, which is why we have got this right back to this exclusion. But as Gareth quite rightly says, it applies to anyone that is not otherwise excluded, and there will be an EL exclusion under the policy. So the EL exclusion will take out injury to staff that might otherwise have been picked up potentially for bodily injury. For example, if you stand too close to it, maybe it'll run over your foot. That might hurt, and you know, that would be bodily injury caused by the aircraft. So it's intended to cover third party liability policy, and the EL exclusion will take away the injury to staff, as Gareth said earlier.
Excellent. Yeah, I think that's very clear, Yeda. And I agree that an aircraft running over your foot probably would hurt. Can't say I've experienced it. Don't think I'd like to. So I think we need to jump on one more slide, and then Gareth, if you want to continue from where you were. Thank you very much for the question, Naomi.
Yeah, absolutely. So let's just look at a few more exclusions within AVN 104. We've seen them already today. So the first one is that construction exclusion. So we're not going to cover major construction projects, only normal maintenance operations. Now you will quite often see this written back to a degree under an airport liability policy, but that's the standard exclusion. The next one, control tower, air traffic control services. Important for the broker to understand what the insured's responsibilities are in this regard, particularly around control tower, you know, because quite often the airport operator will have some degree of airfield control tower exposure. So you need to work out whether you need exclusion 11 in its unamended form, or whether you need to make modification to that based on the insured's exposures. And then the final one, an air meet, air race or air show exclusion. Again, understand what the insured's exposures are. Are there any air meets, air shows taking place at the airport, and do you need to modify this exclusion to cater for those exposures? And then moving on, thinking about modifications, we're now sort of departing from the core AVN 104 form. And I just wanted to talk you through some of the common extensions that we see to policies, and have a think about what they might be there for. So the first one, supplementary payments. And if you were with us on an earlier session, we talked about AVN 76 in some more detail. So expenses for search and rescue, runway aircraft foaming, removal of wreck, public or CAA inquiries. Quite often you're going to see that appended to a policy. As we talked about previously, it is worded for an aircraft operator. So if you're going to attach it to a products or an airport policy, then it would need some amendment. The next one, tenants' legal liability. This one comes up quite often in discussions. And what we're talking about here is damage to premises that are owned, rented or occupied by the insured. Quite often not called tenants' liability within a policy or a slip, but more often as a right back to a PD exclusion. And here the exposure really is an insured that rents a facility somewhere. They damage that facility. This provides cover for that damage. And quite often you're going to see a limited amount of coverage for tenants' legal liability under a policy. If you've got a US policy, you might also see fire legal liability, which is a kind of watered down version of tenants' liability, only applying in respect of fire damage. The next one, detention of aircraft. So legal liability that really the airport operator might incur arising out of the improper detention of aircraft. But when that's made in an attempt to comply with a requirement to detain that aircraft. So if the regulator says this aircraft needs to not leave the airport, but that is detained improperly by the airport operator, then the potential for damages that might arise from that, the legal liability of the airport operator is covered by a detention of aircraft provision or extension to the policy. Tony, for the next one, please. So ransom and extortion cover. To cover payments that are made by the airport operator in respect of threats against a person or property at the airport. A ransom and extortion coverage, always provided with a sublimit of some kind, and quite often a co-insurance as well on behalf of the insured. It's not so common, but we do see it on some policies, ransom and extortion cover. The next one, advertisers liability, more often seen on US risks, I would say. So here we're covering legal liability for damages awarded to a person arising out of lots of different advertising activities, but really invasion of privacy, libel and slander, misappropriation of advertising ideas, or copyright, title or slogan infringement. Again, nearly always provided with a sublimit. The next one, medical and related expenses, and we talked about this in more detail in an earlier session, so I won't do that again, but when we're talking about medical, surgical, ambulance, hospital, repatriation of bodies, funeral expenses, and you remember we talked about previously where this is, whether there has to be BI and an occurrence, but there doesn't necessarily have to be liability on behalf of the insured. But medical and related expenses payments can be made. Tony, the next slide, please. So air meets and air shows, quite often important for an airport operator, and normally we would expect to see that included on a per air show or per air meet basis. So you'd have exactly where the air show is going to take place and what date it's going to take place on, but excluding BI or PD caused by a participant in the air meet or by any participating aircraft, vehicle or device. So the participants in the air show should be carrying their own insurance, and that liability shouldn't be for the airport operator to pick up, but the airport operator would pick up the more general liability arising out of an air show, so spectators falling over in the stands, something like that. Non-owned aircraft liability, we've touched on it a few times, so BI or PD caused by an occurrence arising out of the use of a non-owned aircraft. I mentioned that for an airport operator, they quite often use a non-owned aircraft to calibrate runway ILS systems. Typically, we'd see that with some kind of seating limitation, so then we know we're not covering a 737, we're covering a little 5-seater aircraft to do that kind of activity. And we would exclude damage to the non-owned aircraft itself, only liability arising out of the operation of the aircraft. And then non-aviation excess liability, a slightly more common one, which we've talked about in previous sessions again. So providing a level of cover excess of underlying non-aviation policies, typically EL or auto liability policies. Now, it's important to remember, and I've seen examples of this not being done, where you just get a non-aviation excess liability limit put on the slip. But if you're, for example, you're using 98A or AVN104, there is no wording behind that. So you need to make sure that you've got a wording to actually provide the excess liability cover, and AVN37B is the standard way to do that. So next one, contract works. We looked at that construction exclusion a couple of times already. Quite often we'll see a contract works inclusion added to the policy. So to say, for example, that we will cover contract work subject to the value of the contracts not exceeding X amount. It might be per contract or an aggregate amount of works that can take place in any one policy period before insurers have to be notified. And then the last one that I've put on there is the corporate manslaughter clause, which is AVN108. And this provides for coverage for defence costs and expenses where there's been an occurrence and where the insured has to be represented at a court, including criminal courts, for actual or alleged breaches of the Corporate Manslaughter Act primarily, but also the Health and Safety at Work Act, or legislation similar to the A and B in another country, if that's scheduled on the policy. This again is normally provided with a sublimit of cover. I think that's my last slide on AVN 104.
Thank you very much, Gareth. And we do have a question in the Q&A facility. The question is, by detention, is this similar to confiscation? And I think here we're referring to 48B and the reference to confiscation, nationalisation, seizure, restraint, detention, where both terms are used. I've had a quick look at the, I guess what we would term the normal meaning of the words, but Gareth, I'll hand over to you just to see if there's any, if you've got any initial views on that point.
Yeah, I mean, normally when we're talking about detention of aircraft extension that we might give under an airport policy, we're talking about the aircraft being detained really because there's some kind of lien on the aircraft for unpaid something. So it might be that the finance charges on the aircraft haven't been paid and therefore someone's executing their lien and the airport operator's been told not to release the aircraft because of these unpaid dues. It could be that they haven't paid for their air traffic control fees, so the air traffic control organisation doesn't want the aircraft to be released. So that's the kind of detention we're talking about. We're not talking about confiscation in a 48B sense, where we're talking about confiscation by government action.
Yeah, did you have anything to add?
No, it's where as Gareth says, it's detention by or at the airport, and the airport is found to have detained the aircraft illegally, essentially, and therefore have incurred a liability for that detention. And therefore, the policy will respond to that that liability. But it's as Gareth said, it's usually for financial reasons. Somebody has a lien on the aircraft, they instruct the airport to not release it, or they may believe that the aircraft operator owes them some money, owes the airport some money, and it turns out to be incorrect, and they detain the aircraft, and it's wrong that they've done it.
Okay, yeah, I think that answers that question very comprehensively. So we'll take a look at the next question that's come in, and that's, could it be usual to cover the employer's liability without an underlying policy? Gareth, do you want to take that first?
Yeah, sure. No. So no, we wouldn't expect to see EL covered on a primary basis. For example, if you look in the UK where EL is a statutory insurance, there's statutory limits that have to be purchased and a statutory level of cover that has to be provided that's in breadth of cover. So it's not appropriate for aviation insurers to provide that statutorily required cover. So we would always expect to see an underlying that at least complies with the minimum limits required by law before aviation insurers come in on a non-aviation excess basis.
Okay.
I would, if I can, I would add just to that there are one or two, it doesn't apply to airports, but it does apply to certain airlines in certain jurisdictions where, although there might be a requirement for EL, a compulsory requirement for EL, when it comes to air crew, there is a requirement for the aviation policy to respond to bodily injury to aircrew arising out of an aircraft accident. And I would say that's probably the only exception that we would see under any aviation policy for what is essentially direct EL under the aviation policy. But to add to just to add a little bit of additional flavour for the non-aviation excess cover, just as Gareth said, it's important to have a wording that says what we're covering under the excess cover. It is equally important to have a wording that shows what the coverage is under the primary policy. And therefore, there should be a clear indication of what that policy is. And I know that in the past, going back a while, I have to admit, but we have seen a self-insured retention. Effectively, basically, the insured had a self-insured retention and a policy that sat above that. Then they did away with the policy, retained the self-insured retention and bought excess off that self-insured retention. That won't work because we don't have a wording that we're excess of. So even the 37 can't come into place because the cover under 37B says the primary must be in full force and effect, otherwise the excess cover falls away. So we have to be a bit careful with that schedule of underlying, that it doesn't sneak in something that actually turns out not to have a primary coverage, a policy attached to it.
No, it's very useful. Thank you, Yeda. So I think, Yeda, we have just under 10 minutes to deal with section 3 of the presentation. And if Tony moves us forward 2 slides, I think we're going to kick off with a poll. So I don't know if you can see the poll yet, but I'm happy to just.
I can see the poll. Yes, I can see the poll.
Okay, so
do you want me to do the?
Yeah,
basically,
go ahead.
We're asking. There are a number of standard clauses that's attached to a facultative reinsurance policy, and we're asking which of these clauses will provide the most control for the reinsurers, and the options are as listed. Make your choice. Do we have a response, Tony? Thank you very much. This is it's a good response, and the right answer is AV41A, which is most of our respondents have identified. The full reinsurance is I guess until we learn about the clauses, the full reinsurance might imply that the reinsurers have control, but in fact it is the opposite. And of the other clauses, the claims control does not give underwriting control, and AV21 we have 6 respondents for that. So good answers, I would say. Thank you very much. If we can have the next slide, and we'll skip through these. I'm hoping that most of our participants in this webinar are familiar with direct insurance and facultative reinsurance. Facultative reinsurance is where we reinsure the direct risk for one reason or another, usually because the local regulations provide that a policy is insured with a local insurer who can then reinsure into the international aviation market. Often a local market won't have the financial capacity to cover the risk nor the appetite for that type of exposure under an aviation policy. And where we have these less experienced markets, the London market, who would normally write these risks on a direct basis or similar risks on a direct basis, will require underwriting and claims control, and that is afforded under AV41A. The language is quite clear. We're reinsurance of the named company, and it is warranted to be on the same gross rate terms and conditions as those applying to the reinsured as agreed at inception. We will often see that the gross rate might be taken away, but it has to be, the terms of the policy have to be the same. Also, the warranty of a retained percentage by the local market might be removed. but the condition precedent under 3A, B, C are retained. Amendments to the policy can't be made without prior agreement from the reinsurers, other than as may be stated in the policy. The reinsurers might accept additions and deletions, etc. That's known at the outset, and that is accepted or may be accepted. We'll see. It depends on the policy construction. The reinsured must advise of any loss. They might give advice under a policy. But I think there's some misunderstanding here from time to time, because it's often amended to 7 days. However, it doesn't need to be 7 days, because the reinsured shall upon knowledge of any loss. So it's when the reinsured has that knowledge that they have to notify reinsurers. And one would think that 72 hours is more than sufficient in today's environment to notify the reinsurers that there is a loss or potential loss. And the last bit, which is where underwriters retain the claims control, is that the reinsured must provide all relevant information, and that the reinsurers are the ones who appoint adjusters, assessors, etc. So can we have the next slide, please, Tony? AVN25 is a claims control clause, and it essentially picks out the bits from the AV41 relating to claims. We don't see it so often. It depends on the quality of the reinsured, whether we use a claims control clause. And there may be some jurisdictions where underwriting control can't be given to reinsurers, but it gives the underwriters a tool if they're happy with the ability of the local company or the reinsured to underwrite the risk. Then reinsurers retain claims control. Next clause, next slide, please. And the AVN21 is a softer clause in that it's a claims cooperation clause. And the language there is 7 days to advise that there's been a loss, and that the reinsured will provide reinsurers with information and will cooperate in the adjustment thereof, but not control. And if we can skip on to the last slide, please. And this is where we have where we may have some confusion. A full reinsurance clause doesn't mean that the reinsurers have full control. It actually means the opposite. It says where it's a reinsurance of the reinsured is subject to the same clauses, terms and conditions of the original policy, and it shall follow the settlement of and shall pay as may be paid by the reinsured. Sometimes we may even see language that says liable or not liable. Obviously that's uncomfortable language, because we don't want to pay outside of the terms and conditions of the policy that we've accepted at inception and agreed to reinsure. But even in those cases, we will generally see language that says any ex gratia payments are to be agreed by each reinsurer for their own participation. Ex gratia payments are payments that are made even though they're, to all extent and purposes, are not covered under the policy. So not many insurers these days are even permitted by their claim settlement authority, etc., to make ex gratia payments without getting a very high level sign off. Quick canter through the reinsurance clauses, but hope it's helpful. Thank you.
Yes, certainly is. Thank you very much, Yeda. And I can see that Gareth has his hand raised. It's actually the first time I've seen that function used. So we better go to Gareth.
That was a mistake. Sorry about that.
Okay, brilliant. First unintended use then. We do have a question. It's come through via the chat. So the question is, if the local policy has different gross rates to the London facultative policy, what are the implications in the event of a claim? Yeah, did you want to start us off on that one?
Well, yes, I can start you off. If we're on an unamended AV41A, then as it's a warranty, then the reinsurers could say, well, no, this isn't the policy we underwrote, and therefore we're not reinsuring you. There are times when a local policy is written at higher terms, but it needs to be understood by the reinsurers how that policy is constructed. We see offers into the market where the reinsured is trying to simply provide a net rate and take the warranty of AV41 regarding rates out of the contract. But there are some concerns regarding grossing up, and of course, in the London market, we're not allowed to gross up. So we have to stick to those terms. We have to understand how we're writing the risk, and it could be quite significant if insurers were not aware why there was such a large discrepancy between the gross rate charged to the insured and the gross rate offered or accepted by the reinsurers. So not a practice that is to be recommended.
Okay, that's excellent, Jette. I will ask Gareth if there's anything to add, and Tony will just move forward 2 slides whilst I do that.
I think on that question, Tom. No.
Okay, we have another question that has just cropped up in the chat. Perhaps we have time to just fit that in quickly. So is a follow the fortune clause the same as a full reinsurance? Jette?
Essentially, yes. Yes.
Okay. That was a quick answer as promised. We have a lengthy question that's come into the chat referring to tech records. So maybe we'll quickly read through that and then maybe fit in a quick response. So, so apologies for going back to technical records. Under first party spares and third party hanger keepers, I've seen the following in a slip: to cover costs and expenses arising from loss of or damage to tech records of the insured spares/engines, first party, and or aircraft equipment not owned, rented or leased by or loaned to the insured, which is the third party element. The question is, with respect to hanger keepers, is this then not necessary if tech records would be picked up under the hanger keepers without the need to reference tech records?
I answered the previous question, I think, and technical records are not covered under the hanger keeper section. It's only covering damage to the aircraft. Technical records are not part of the aircraft. It's a separate asset, and it has to be covered under a separate section. So the question, that last part of the question does not make sense. There is a need for a separate section.
Okay, yeah, well, in itself, I think that's a useful answer. So thank you very much, Jette. So we'll take a look at poll number 5. So we are skipping one, Tony, just for your information. So if we can bring that up on screen now. Here we go. So we'll be asking this question twice, once for those involved in claims handling, and a second time for those involved in contract formation. So don't worry if you're not involved in claims handling, your time will come in a moment. So the question is, if you're involved in claims handling, how important do you think it is to have a detailed understanding of contract wordings? The choices are, I'm not involved. The second is, it's not that important at all, really. Then it's somewhat important, definitely not a priority. Then it's important to have a sound understanding, or it's essential to have a sound understanding. So if you could just select the appropriate response. I think we're already halfway there as far as I can see. So hopefully quite a simple one. Yeah, Tony, if we could have a look at the responses, that would be great. Okay, so as expected, not everyone is involved in claims handling. We've got just under 60% of the responses say it's essential to have a sound understanding, which is fantastic. And just over 10% say it's important to have a sound understanding. And thankfully, nobody suggested that it's not important at all, or it's only somewhat important. So Tony, if we now go to the next poll, we'll give everybody else the opportunity, or at least those involved in contract formation, same question and the same options. So if you could select your response now. And then Tony will have a quick look at the responses. There we go. So interestingly, also 60%, or in the region of 60% of people saying it's essential, but actually slightly more, slightly higher number saying it's important to have a sound understanding, which I think is just because maybe there are some more people who are involved in contract formation and there are in claims handling, but it's good to see a similar amount. I think it's absolutely essential. So just very, very quickly, and it will have to be just a few words, I think. I'll go to Yeda first. Yeda, do you agree with the sentiment that we picked up there, that most people think it is essential, but some people think maybe it's just very important, but not paramount to have that true understanding of contract wordings?
I would say that it's certainly important to have an understanding of contract wording. I think in most organizations, depending on what your role is, depends on how much you need to know about it. And so from a claims perspective, I think you need to have a good knowledge, a sound knowledge of those products you're involved in on the claim side, but you should always be able to refer to somebody who has more experts or more experience than you have, perhaps. When it comes to the contract formation, depending on what your role is in that, depends on how much knowledge you need to have. But again, I think it's important that you have an understanding of how it fits together, and so you're able to advise particularly if you're a broker, that you can advise your clients appropriately.
Thank you very much, Yeda. And maybe just a couple of words from you, Gareth, if that's okay.
Yeah, absolutely. I mean, it's clearly a very important topic. It's part of what we're selling. The promise to pay is underpinned by this contract, and people need to understand what that contract says. Like Yeda mentioned, there are experts within each organization on contract wordings. We're not expecting everyone to be an expert, but everyone does need to have a baseline knowledge. Early in my career, and I would say that this has got a lot better in the market, but it's like broker and underwriter and the blind leading the blind as to what's actually being signed up to on a slip. And it is important that everyone in the process, whether it's a broker, an underwriter, a wedding specialist, a claims handler, everyone needs to have a good understanding as to exactly what the contract does.
And
Thank
if
you.
I can add, Tom, if I can just add a bit to that.
Very quickly.
It will be very quick. And if there's something you don't understand when you're working on a particular issue, to have enough knowledge to know that you don't know and therefore refer it. Because as Gareth said, we did have the blind leading the blind, and we have seen some instances where a client's expectations have not been met, or an underwriter's expectation of the claims that were payable under his policy have been somewhat exceeded by the reality of the contract formation. So I think it's equally important to know that you may not have all of the information, and if there's something that's a little bit quirky, that you have somebody you can refer it to.
Yeah, I couldn't agree more. And I just encourage everyone to bear with us for one more minute, as we've got a few pieces of important information to get through. If you could just go to the next slide, Tony. It's just for me to wrap up, and I'll do this as quickly as possible. So I want to firstly thank everyone who has joined any of our 4 masterclass sessions. I know many people have managed to attend all of them, which is fantastic. I think we've had over 100 individuals at each of the sessions, which pretty much demonstrates, there is a real interest in this topic at this time, and I think so there should be. We've also appreciated the fact that there's been so much engagement across all of the sessions, lots of people getting involved in the polls and the questions, which is very valuable. I do want to thank just very quickly the IUA's events manager, Deborah Finch, and Tony for all of their work in putting these sessions together. And of course, a special thanks to Sophie Moysan firstly, who participated in our first 2 sessions, and then equally to Yeda and Gareth for their fantastic presentations and the knowledge that you shared during the sessions. I hope everyone agrees that we've had some exceptional content from our speakers. On the administrative side of things, I do need to confirm that we will circulate the recordings and the slides from all of the sessions jointly, and that will be in a few days' time, so do look out for those. If you have any other questions, you want to get in touch with the speakers, you're interested in joining our junior aviation practitioners working group or anything else, just let me know. My details are on the website. And then the final points that we wanted to raise that have really come to mind during this process. Hopefully the IUA's Junior Aviation Practitioners Working Group, it's a group now of 50 members from across the claims broking and underwriting communities, is very much demonstrating that communication between practitioners is absolutely paramount and of course often beneficial. Secondly, we would encourage all junior practitioners, as we've just mentioned, to take every opportunity to ask questions of your peers and of course experienced practitioners like Yeda, Gareth and Sophie and equivalents in your organisations. And lastly, I'd encourage you to all continue taking an interest in policy wordings. It's certainly an important part of the process, as we've mentioned, and do keep an eye on what IUA, LMA, such as the Lloyd's Market Association, and LIBA, the London and International Insurance Brokers Association, are doing in respect of aviation insurance. And of course, do get involved in AICG consultations on model AVN clauses. So I think we've just got on screen here an overview of all of our sessions. We have got the 2 claims masterclasses now. Obviously, this is an opportunity to apply the learnings from the wordings masterclasses to some claims scenarios and to try and draw some of the key considerations for claims practitioners out through those scenarios. These sessions are specifically aimed at junior practitioners, but they aren't only for claims representatives. It's also we're also more than happy for underwriting or broking or anybody else who would like to be involved to do so. So I think with that, and with my apologies that we're slightly over time, I can bring the session to a close. Thank you very much again for joining, and thanks to Yeda and Gareth for another fantastic session.